Good evening, students. This is a lecture on Module 11, Freedom of Expression. In Module 11, we are beginning a study of enumerated civil liberties. This module and the next few to come will do that. Module 11 in particular looks at some of the enumerated liberties found in the First Amendment: speech, press, peaceable assembly, and petition. In this lecture, I will review just the material relating to the freedom of speech. I'll be reviewing most, but not all, of the material relating to this freedom, but in a slightly different arrangement. My lecture does not cover any material on the freedom of the press or the freedom of petition and assembly. You'll need to read and study the entire chapter 11 in your textbook carefully, and be sure you understand the rest of the material. If you have trouble, please reach out to me for help. But what I'm going to be doing in this particular lecture is just offering a different way of arranging that material on freedom of speech, just in a way that I think that is a little bit clearer than what you see in your textbook is the way I'm going to present it here. And I'm also going to include discussion of a very recent Supreme Court decision on student speech. To begin, we need to make a distinction, and that is between laws that put in place restrictions on the time, place, and manner of speech versus restrictions on the content of speech. Time, place, and manner restrictions are the rules that they're typically local ordinances that regulate the use of public forums. The textbook explains what a public forum is. These types of regulations are upheld as long as they are viewpoint neutral and otherwise satisfy the rational basis test. They must be rationally related to a legitimate government interest and not applied arbitrarily. Time, place, and manner restrictions often require speakers to obtain a permit for holding assemblies or events or protests or marches, political rallies, such as you see here from the civil rights movement. So they're just asking that people get permission before they conduct these assemblies. And as long as they are viewpoint neutral, they're rarely controversial. But they have to be viewpoint neutral and applied fairly to everyone. Content restrictions, however, are controversial because they take the form of censorship. And government censorship runs against all aspects of democracy and quite rightly should be prohibited. Generally speaking, the First Amendment prohibits censorship by the government, both the federal and the state government, with just a few limited exceptions. The freedom of speech protections have been selected for incorporation into the 14th Amendment's protection of civil liberty. And keep in mind that the prohibition only restricts state action, not private conduct. Private companies can censor and the First Amendment would not apply to those scenarios. It only applies when the government has enacted a law or some government actor has performed some action that restricts speech. Only then will the First Amendment apply. What constitutes speech is interpreted very broadly. It's going to include symbolic speech, which is just expressive conduct, something a person does to convey a message without actually using words. An example of that is flag burning, something that we saw in the Texas versus Johnson decision that your that your textbook reviews in Chapter 11. Flag burning is a form of expressive conduct and it can be protected. Political spending, that's another type of speech that we've actually studied before. When a person spends money on political expression, as explained in, there were two cases, Buckley versus Vallejo and Citizens United versus FEC. In both of those decisions that are noted in your textbook, the Supreme Court has said that when you spend money on political expression, you are protected by the First Amendment. And it comes up in campaign finance laws because of the implication that you are buying support of the candidate that you're supporting with your political activity. And so the Congress has enacted laws that limit the amount of money that can be donated directly to candidates. That's not protected. But the candidate spending, your spending unrelated to the campaign or a specific candidate, excuse me, you're spending independently of a candidate or campaign is protected. People often express themselves through where they spend their money, and particularly spending money on political expression is protected by the First Amendment. You're right not to speak. That's also protected by the First Amendment. And we saw an example of that in the case of West Virginia State Board of Education versus Barnett in your textbook, where the court said that a person cannot be compelled to say the Pledge of Allegiance. The First Amendment protects a person's right not to speak. When the government does censor speech, the courts will apply strict scrutiny. That is the highest standard or measure that is the government's burden to satisfy when it violates the First Amendment. You can look back at your notes to see what the elements of a strict scrutiny test are. There are occasions, however, when censorship is permitted. So these would be considered exceptions from the First Amendment's protection. And they include obscenity. What is or is not obscene was the issue in a particular case called Miller versus California. If speech is deemed by a jury to be obscene, then speech can be censored. And the court gave in the Miller decision a test for determining what is obscene or what is not obscene. It's a three-part test, sometimes called the Miller test, sometimes called the SLAPS test. You can read about that in your textbook, what the test actually is. And note particularly that this is a test applied by juries. It's a local determination of what is or is not obscene. There is no national standard for obscenity. It's determined by local community standards. Speech that actually harms others can be censored and would not be protected by the First Amendment. And the textbook includes an excerpt from a very important case called Virginia versus Black. That particular case involved specifically cross burning, but it gives a pretty good review of the legal principles relating to harmful speech and when harmful speech can be prohibited. Particularly with respect to cross burning, though, cross burning is a form of hate speech. And there are many laws nowadays that are intended to prohibit hate speech. Laws that prohibit cross burning are just one example. And in the Virginia versus Black case, the court made it clear that cross burning, laws that prohibit cross burning must include the element of an intent to intimidate. It's when someone is using cross burning or otherwise using your words in order to intimidate and frighten and harm someone, then that is a true threat that can form the basis of a criminal prosecution. So if cross burning is combined with other evidence of an intent to intimidate, then it can be prosecuted. However, hate speech alone, without an intent to intimidate, or that actually harms another person, is protected by the First Amendment. And there was an example in your textbook involving a particular church, Westboro Baptist Church, where they were protesting at a funeral of a soldier. They were just speaking. It was considered just speech and not with an accompanying intent to intimidate anyone. So hate speech alone is protected by the First Amendment. But when it's coupled with other conduct that shows an intent to intimidate or harm someone, then it is not protected. Commercial speech can also be considered harmful when it is false or misleading. And when it is false or misleading, it can be prohibited. You can think of private advertisements, commercials on TV, if they are the regulatory authorities for commercial speech can prohibit false or misleading advertisements. That type of speech is considered harmful and is not protected by the First Amendment. The First Amendment also arises sometimes in defamation lawsuits. Defamation refers to spoken or written words that actually harm others. And when it actually harms others, it can be prohibited. But note there is a distinction in the elements that a plaintiff has to prove in a defamation lawsuit. The difference could be if the person is a public figure, they have a higher burden than a private actor would, a private citizen. And then when the content of the speech is a matter of public concern, then or versus private concern, then the rules are a little different. The distinctions are going to determine whether the harmed person has to present evidence of actual malice on the part of the speaker. But in the main elements of a defamation case involve proof of actual harm. So this is speech that actually harms, and therefore it can be prohibited by the law. Speech can also be censored when it is intended or likely to incite imminent lawless action. So this is where no actual harm has occurred yet, but is just about to occur. It is imminently going to occur. And the speaker intends to incite this imminent lawless action. We saw this in the case of Brandenburg versus Ohio, where a group of KKK members held a rally in the woods, holding guns, burning crosses, threatening harm, threatening property damage, and an assault on government authorities. But there was no audience. So those threats were empty threats, and there was no imminence of the lawless action that they were inciting. So the hate speech in that case was protected by the First Amendment. The issue here is not the actual harm, but the potential for the harm. And that's why the imminence of the harm is so important and the intent to incite is so important in these cases. And it's very similar to some discussion in your textbook about fighting words. The textbook kind of presents the material separate from the imminent lawless action material. I'm not sure why it was separated that way because they are pretty much the same thing. In the Chaplinsky versus New Hampshire case involving fighting words, the court was saying that fighting words can be censored because they're provocative. They're going to provoke a fight. The person who hears the words is going to punch the speaker of the words. So you still see the intent to incite. You still see the imminence of the lawless action, whether it's fighting words or hate speech. It's the same thing. Those types of speeches can be censored because of the likelihood that harm will occur. Unless, in some very narrow circumstances, student speech can be censored by schools. When a student is on campus, school takes on the role of parent in a certain way. It's the philosophy of in loco parentis, in the place of the parent. So if your parent could make you shut your mouth in certain circumstances, when you're on campus, the school can do likewise. So there are some kind of narrow circumstances when student speech can be censored. These include speech that violates school policy on indecency, bullying, or drug use. Some examples are given in the Bethel case, Bethel School District versus Frazier. In that case, young man, Mr. Frazier, gave a very vulgar, sexually vulgar speech to a group of fellow students at a school assembly. and he got in trouble for it, and the court upheld the school's decision to punish him because what he said violated school's policy on indecent or vulgar conduct. Another case, Morse versus Frederick. In that case, the student, Mr. Frederick, pulled out a banner that said "Bong hits for Jesus," and got in trouble for that because it seemed to be promoting drug use. And the court allowed that punishment as not protected by the First Amendment because it violated the school's prohibition on drug use by students, or conduct that encourages drug use by students could be prohibited. What's one situation that is not in your textbook because it's too new is the case Mahanoy School District versus BL. And that case involved a very angry cheerleader who was cut from or when she was trying out for the cheer team, she got put on the JV team, not the varsity team, made her very angry. So she posted some pretty vulgar comments on Snapchat. Um, and got in trouble for it. She posted those comments when, outside school hours, off campus, on her own business. And the court explained that the First Amendment's protection covered her. And this is, in that particular case, it had to do with the fact that the student was off campus when she made these lewd comments. And so that was the reason why the court gave First Amendment protection to that student. But really, the difference between conduct on and off campus, that isn't determinative. You can, for example, if a student is bullying another student online through social media, that student can be punished for violating school policy on bullying, even though the bullying was taking place online and not directly on campus. So that's not a determinative factor generally. It just happened to be so with the cheerleader case. But that decision gives a really good discussion of when student speech can be censored and when it cannot. And so I believe it's important for you to read and understand. Students don't lose their free speech rights when they go on campus, but those free speech rights can be restricted in certain instances, such as I was saying, when it violates school policy on indecency, bullying, and drug use, or when it is attributable to the school, as was the case in the Hazelwood versus School District, where student Kohlmeyer wanted to print a newspaper article involving a discussion of teen pregnancy and divorce, and her journalism teacher pulled the story from the publication because he had determined that they did not have consent from some of the people involved in the stories that were being printed in the article or would have been printed in the article, and it would disclose very personal information about people who had not given their consent to disclosure. And in that situation, the Supreme Court said that the Mrs. Kohlmeyer's article could be pulled from the student newspaper, that the school had acted properly because this was a publication that was part of a journalism class. The teacher in the syllabus had editorial control over what was being published, and the material could be attributed to the school. It was in a school newspaper. Believe, yeah, there is one other case which explains that student speech can be censored if it materially or substantially interferes with the education process. So you can imagine a situation where high school or middle school students, stand up in class and start preaching or asserting their political beliefs openly and disrupting the classroom. That type of speech can be censored. They can make the student be quiet and sit down and behave. The case, though, that provides that principle, that is a case where students were not disrupting class. You can see the two students depicted on the slide. They were simply wearing armbands to protest America's involvement in the war in Vietnam. And because that wearing of armbands did not interfere with the education process, their speech was protected. But we have that case as providing us this principle for when student speech could be censored if it does interrupt the learning process. All right, that's all I've got. I've just tried to take the information relating to freedom of speech that's in Chapter 11 and rearrange it a bit in a way that I think just makes more sense and is easier to follow than the way it was presented there in the book. But go ahead and read all of the material in that chapter, including the material on the press and assembly and petition. I just because I'm not lecturing on it doesn't mean I don't want you to learn it. I just feel like the textbook adequately covers it. But if you have any trouble understanding it, please reach out to me. Don't muddle through. Give me an opportunity to explain it and to help you learn it. You can reach me on my office phone through email, or if you're an on-campus student, feel free to drop by and I'll be happy to go over it with you. Otherwise, y'all have a good day. Thanks.